Good morning, Ms. Real Schmidt.
Good morning.
Please get settled, and when you are ready, you may begin with your opening comments.
It is good to be back and to see all of you again. I do want to thank you first for your dedicated work on this important commission. When I was here last August, I talked to you about my history and the breadth of my experience. I talked about the diversity of the places I've lived, both rural and urban. And I talked about the diversity of the folks I've counted as my friends and neighbors, my colleagues and clients. Today, I want to talk to you about who I am professionally. I'm a lawyer, I'm a teacher, I'm a hard worker, I'm a team player, I'm an author, and I'm a public servant. Because of the many hats I've worn and I continue to wear, I have 4 unique characteristics that make me not just a good candidate for this Court of Appeals, but one of the very best candidates for this Court of Appeals. First, I have a singular expertise in legal analysis and writing, as well as a unique expertise in interpreting other folks' legal analysis and writing. Legal analysis and written communication are the core skills for this Court of Appeals. In law school, while you take subjects by topic, it may be evidence or constitutional law or things of that nature, what you're really tested on and evaluated at the end of the day is on your ability to analyze and communicate your analysis in writing. And I was pretty good at that. As I went into practice, I continued to refine those analytical and writing skills in the same way that most lawyers would do. But then I became a teacher. And to teach those core skills, you have to do more than tell your students, watch what I'm doing and do that. You have to really figure out the methods, templates, processes for legal analysis and writing. So when I returned to practice, I had a more deliberate process for analysis and writing that made me much more efficient, and it helped me deliver a better product. But my experience as a teacher not only gave me a depth of expertise in my own analysis and writing, that experience also made me an expert in understanding the analysis and writing of other folks across a broad spectrum of talents. In the 11 years that I taught, I reviewed in the neighborhood of 250 appellate briefs and 1,000 legal memos. It isn't very helpful to students if you just say thumbs up, thumbs down, or give it a big red pen mark and go on your way. You really have to understand what they're saying. You have to understand their analysis, their communication, warts and all. You have a limited amount of time to review a lot of papers, translate what they're trying to say, their analysis and their writing, so that you can give them some meaningful feedback. On the Court of Appeals, being able to quickly absorb and interpret what folks are trying to say, regardless of their ability, is as important as the core skills of being a deliberate analytical thinker who can quickly and clearly communicate. I've heard the Court of Appeals described as a workhorse, but I see it as a team of workhorses. The most essential key in picking a workhorse to join the team is the strength of their training in the core skills, analysis and writing. But the second most essential attribute is their ability to join the team and complete the work without missing a beat. That is a proven track record of being a team player. And that leads me to my second point. I have a unique and proven track record of being a team player, a collegial collaborator. I've collaborated as a lawyer, writing briefs, preparing for hearings, preparing for trials, and the like. But as a teacher, I collaborated every single day. I worked, listened, and refined with my colleagues in the trenches to create the best techniques and materials to teach our students. Beyond that, I collaborated with a colleague on a book. For months, we worked to match our writing so that it was a seamless transition from one chapter to the next. We ruthlessly edited each other, and we welcomed that ruthless editing. we had to decide what would go into the book as a team, and we each had to push certain points, and we had to concede on certain points. In my current practice, representing Medicaid, I am in constant collaboration with folks, not lawyers, folks on the ground. We are working always to solve problems, ensure compliance, and create processes to avoid problems. These folks have subject matter expertise that I don't have. And so when they have something to say on those matters, I'm going to yield to them. When I have things to say about the legal aspects, they yield to me. I bring a proven record of collegial collaboration in a variety of areas. So when you've picked the horse that has the best strength in the core skills of analysis and writing, and a proven track record of working with a team, then you can look to some of those other collateral things that might benefit the team. The third thing I would bring to the Court of Appeals is a unique expertise in transactional drafting. I've had that breadth in transactional work, writing title opinions, writing wills, writing contracts, participating in business litigation. But the depth of my expertise, again, does come from teaching. In 2006, I created a transactional drafting course, the first of its kind at Drake University Law School. I was fortunate to have a mentor, and she was a lawyer turned professor. She was in the process of writing a book. She let me use the draft of the book, and I continued to use it. She was always a phone call away. She had far greater transactional experience than I did, and she had far greater transactional experience than most of the lawyers I know. I learned from her that I had been practicing somewhat imperfectly. She taught me, and I taught my students, in her words, how to translate a business deal into a legally enforceable document. Most of business litigation is about the breakdown of those transactional documents. And in learning and teaching, I gained a depth of knowledge in transactional drafting that would serve this court well when navigating transactional litigation. Last, because of the many hats I've worn as a lawyer, a teacher, an author, a team player, a hard worker, and a public servant, I'm different, and that's a good thing for the Court of Appeals. I am not a district court judge, and I am not an associate district court judge, and that's okay. That experience is valuable, but you have 4 folks like that on the Court of Appeals right now. And I'm different from the other candidates because of the different hats I've worn. But my differences are good. That diversity is good and would be a valuable thing for the Court of Appeals. Because of my many professional roles, the expertise and the essential skills necessary for this court, my proven track record of collegial collaboration, and my expertise in transactional issues, I'm exactly what this Court of Appeals needs right now. I am the horse to join the team, and I am the horse to bet on. Therefore, I would respectfully request that you would nominate me to the governor for this position on the Court of Appeals. Thank you.
Thank you. And we will begin with some questions from the commission. Mr. Hoytig.
Thank you, Ms. Schmidt. We've had some conversations about your current position, and I believe I've shared, Medicaid's a scary word. It just sounds very confusing, and most of us want to run away when we hear it. Could you continue to help demystify kind of what your practice is today and what you do so that we can understand how broad your experience is as opposed to kind of maybe wrongly thinking that you have a very narrow practice on a federal issue. Can you talk a little bit about what you do so that we can understand that a bit better?
Okay, so I will just focus on my work with Medicaid, but I have a broad experience across many areas.
Yes.
But as representing Medicaid, I see that as being similar to being in-house counsel. So I represent them in administrative appeals, but I do a lot of work on helping create processes. Often you'll see a problem come up, and there are 2 approaches and 2 things that you have to do. Obviously, you have to solve that problem. but you also have to look to the future and think, what can I do? What can I put in place? How can I work with these folks down here to make sure that problem doesn't occur again? So I work a lot on processes with the folks down there. I work with them to ensure compliance. I help write regulations. Gosh, what do I not do? I think that's really the question, but it is very broad, and you can probably identify a little bit better because you are in-house corporate counsel, but the day is never, you can't always anticipate what's coming your way. You just have to get in the way of it and solve the problem.
Thank you. Ms. Valentine?
No questions.
Mr. Berger?
No questions.
Ms. O'Brien?
Yes, could you give us a little more detail, or maybe big picture, on the Medicaid litigation that you're involved in? My uninformed assumption would be that it's mostly monetary disputes between providers and the state. Is that true?
No, it's a little bit broader than that. So there are monetary disputes where Medicaid may recover what we call an overpayment. It's a debt from a provider because perhaps they've submitted claims that shouldn't have been paid. Maybe they upcoded or something along those lines. So that is one type of monetary dispute. I work with the Program Integrity Unit at Medicaid too, and their job is to prevent fraud, waste, and abuse in the Medicaid program. And a part of that is they have the power to impose sanctions. And those sanctions may run from probation to completely terminate a provider's participation in the Medicaid program. So I work on those sorts of administrative appeals. We also have vendor appeals. So when the state puts out and asks for folks to make proposals on a contract, vendors who are unsuccessful are not always happy. And so I work defending those sorts of things as well. Another monetary issue is something nobody ever wants to learn about, is called provider cost reports. It's sort of I would call it similar to a tax return that certain providers have to complete because they're paid based on their cost by the state. Those are ugly. They are about money, but they're very complicated and intricate, and I've gotten to know a lot more about cost reports than I want to know. But so there are a pretty good variety of different things that you're defending in addition to working on actually creating proactive processes to ensure that you don't end up with those little explosions somewhere along the line.
Thank you.
Mr. Sukup?
Good morning.
Good morning.
When you taught the classes on your judicial writing class, what was the major differences between district court opinions and appellate court opinions?
So on the district court opinions, clearly what the district court is deciding the facts in the first instance. So the facts come before the district court and they make the determination on that. When you're looking at an appellate court opinion, they're reviewing obviously the record to determine whether the record supports the conclusions. And so I think it's more of a pure legal analysis than at the district court level, where there are a lot more things going on.
Okay, thank you.
Ms. Conover?
You addressed some of the issues I was thinking about as far as your application with the teaching background and what that brings to the court. And I'm thinking myself about when I used to coach high school mock trial and would have to explain rules of evidence to high school students, and I think it made me a better trial attorney to understand those rules of evidence. But what is it about having to learn, I presume, how to separate kind of the wheat from the chaff in your students' writing that you see translating to a busy Court of Appeals docket with a wide variety of effort that's been put forth in written product, and having to try to quickly digest all of that and come up with the correct result?
Yeah, so I do think that review of student work really helped me. It helped me when I went back to practice. I really noticed how when I got a brief, and we all understand that some briefs are better than others, and when you get a brief that isn't one of the better ones, as being on the other side, you need to understand what they're saying, even if they haven't said it very well. And I had a young lawyer in my office ask me this recently, do I have to figure out what they're saying and address those arguments? And I said, absolutely. You absolutely have to do that. And so I think just that repetitive process of doing it over and over, and I think, again, across this very broad spectrum of talents, made me much more efficient at doing that when I came back to practice. And it's the first thing I do when I get a brief. I sit down and I write on another piece of paper what their arguments really are. And then I set about addressing them and figuring out how to translate that into putting my best arguments forward before I even get to theirs. You bury those, right?
Thank you.
Mr. Bloom.
Well, first of all, I've always been a zealot for process improvement, so our conversation on that is very rewarding to me, very encouraging. I can't remember if so I don't remember the setup for this question. I frequently talk to applicants about improving the team, so I sort of use a sports team analogy, and I think you said you thought there was a better analogy, that it was more like a group of writers for a television show. Do you want to explain what you meant by that? Or?
Sure. So when we're talking about a team, I think a lot of the focus on a team that I heard, and then as I watched the other interviews, I noticed was we're focusing on, are you a good pitcher? Are you good at this? Do you have skills in this area? But what you want are the folks with the best core skills. So if you're focusing on writing, say, a program for television, you aren't looking for someone who brings an experience, say, my television program is going to be about people who lived overseas. That's not what you're looking for first. First, you're looking for can they write? Are they good at the core skills? And so I felt like the team analogy left off a little bit because we aren't focusing here on, or we shouldn't be, on what those collateral skills are. Those only become important when you pick the person with the best core skills. That's what I think is essential. I think every metaphor fails at some point.
Yeah.
Mr. Gray.
Yes, just a short question. So you have obviously very good writing skills, but what about learning about what to write? How are your research skills? How much experience have you had in actually doing the research?
Well, I think I'm pretty good at that. And one of the things that I think you can look to is that I've written in a lot of areas. So I haven't just written for, as a lawyer, which always requires a lot of research, but I've also written in a lot of other areas. I have some published articles, and I wrote a book, and all of those things require research. When I did my brief stint in Florida, I taught there for a semester as well, and one of the components of teaching there was teaching research skills. So I did teach students to do that, but I think my research skills are probably, I would say they're up there among the very best.
Thank you.
Ms. Law.
Yes, and Mr. Gray, I was a student of one of Ms. Real Schmidt's colleagues at the same time she was teaching at Drake, and we had research drilled into us, so I have a lot of her research skills. Right. I noticed from your application that you've had a variety of volunteer experiences. You were mayor of Steamboat Rock, you were assistant softball coach, assistant cross-country coach, and even involved in a polka club. What of your volunteer experiences or experiences like that could you draw from for the Court of Appeals, or what did you learn?
So I think Commissioner Bevel and I talked a little bit about service and what's important and what's really important to me. And you've seen all the service that appears on my application, and that's what I call public service, all the things I can put on my resume and on my application. But what I would draw from is probably not from those, but from opportunities I've had to practice what I call private public service, and I've had some opportunities to do that in my job, and that's when you have to do something as a lawyer because that's what it's required. You have to defend your client. You have to maybe not give a person the best outcome they would like, but you find another path for them. And recently I've had an opportunity to do that with someone, and I think that that's the same idea on the Court of Appeals, is that you're going to have to make decisions. You're going to make decisions that, as we talked about, they're not hard decisions to make because you know you have to make them, but they don't always feel good. And is there a way at times to find another path, or to use your service to find another path for folks to ensure that sometimes good things happen even though it's not within the context of your work?
Thank you.
Well, Ms. Real-Schmidt, we are out of time. I apologize for that, but thank you for your application. Thank you for being here today.
Thank you all. I appreciate it.
We wish you well.